Bueno, pues reanudamos la sesión.
We're going to resume our session. I see that Mr. Zamora has a coffee right there for support and sustenance, but I do have a question that I wanted to ask.
Before we start, I promised yesterday that I would give the tribunal a progress report of a document we were trying to obtain from a Mexican court. I wanted to give that progress report. I can advise that my colleague went to the court today, had a meeting to review the file. My colleague was able to confirm a copy of this document, which is a draft that I have, is the exact same document that was filed with the court on May 25, 2018. However, the court would not allow my colleague to take pictures. Apparently, in Mexico, you can't necessarily obtain a copy, but you can take a picture of documents that are in the file. The court would not allow my colleague to take pictures. They did say that my colleague, and I'm just reading my notes, could come back and get a copy in January of this coming year, because the court was about to close for the holidays, apparently. So I wanted to give an update. I have two ways to go about this, and I appreciate Mexico will have some comments in response. One, I can get a declaration from my colleague who went and visited the court and make the confirmations. Two, we can address the issue once I'm able to obtain a copy come January, because there's going to be time for the post-hearing briefs and whatnot. Or three, we can ask the assistance of the Mexican government to try to obtain a copy, which I don't know if they have it or not. And to give you by way of background of how this search started, there was a footnote in Mr. Asali's second report that caused us some questions, because the footnote references a document and there was no exhibited document. We asked about the exhibit and were told it was an error to include this exhibit. We can ask Mr. Asali when he gets examined about that, but that's what triggered this. And in preparing for the hearing this week, or this past week, the issue was raised and it was brought to our attention that indeed what's called an alegatos was filed before the court, and this is what I referred to the tribunal earlier, with the bold and conspicuous language of clause 15.1R, and it even has a snippet of the contract provision in it. It's relevant to this arbitration. It's quite material to the outcome of this arbitration, and I just wanted to bring it to your attention.
Okay, I think this is a very substantive issue in which the tribunal will have to confer and discuss, and probably will have to be solved in writing. But on an impromptu basis, I don't know whether respondent want to say something on a preliminary basis, because I think we need to decide on this substantive point in writing and by applying due process, of course. So, señor Bonfil.
No quiero quitar mucho tiempo.
I don't want to take up too much time. This is extremely striking. Let me give you some dates. In April 2023, the reply, it was submitted, and 2 weeks later, we got a request from the claimant to include thousands of pages. And then now, claimant puts a petition to include new evidence, and we have no idea so far what document they're talking about. And there is Procedural Order 1, and at 1515, it states that in exceptional circumstances, one can put a request for including new evidence. But this is a systemic conduct by claimant, and I think that the tribunal must consider this situation. What's relevant, and I agree with you, Mr. President, is that we need to put all this in writing. We need to now listen to the evidence from the experts as scheduled today. And if claimant has something to allege months or years after it should have put its legal strategy in this arbitration, then it can do so. But this conduct is becoming systemic in this arbitration, and this needs to be taken into account. That's the end of my comments, sir.
We'll have to deal with this on housekeeping issues, how we will be dealing with this particular issue as well as others sometime, probably tomorrow when we finish this hearing. So, in light of this question, I will skip what was left of my of the question I had in mind, and I will. A ustedes en español.
I'm going to address you in Spanish. So I'm not going to ask the question that I had in mind, but I had two questions that I wanted to ask of you. And I think these questions will be addressed to Mr. Mesquita. Before the finiquito, you said that certain things happened in administrative contracts, but you also referred to finiquito in connection with contract 821. I heard you say two things. I don't know if I understood them correctly or not. First, that finiquito is an administrative act, but I thought I heard you say that it was also an adhesion contract. Initially, the transcript said it was an aleatory contract, but it's an adhesion contract. So it is a unilateral act, or is it an adhesion contract? Or rather an adhesion, a contract of adhesion? Well, this is another issue that has been quite discussed amongst administrative law scholars. The finiquito initially is a civil law concept, but the law establishes the need to make finiquitos. There is a legal obligation to bring about finiquitos. When I was saying that this could be either considered an act of an authority or an administrative act, well, I said that because in practice, apart from rescission, any contract that is sought to be terminated and that is in disagreement with a determination from the authorities, well, we said that in order to go to the annulment proceeding, I need a written decision from the authorities. And this decision has to be final and in writing. So when we're dealing with these contracts, the terminations of these contracts, the private parties cannot go directly to an annulment proceeding. Why? Because I need first an administrative act that needs to be annulled. So the case law said, okay, the first thing you need to do is to ask for a finiquito. And if that is rejected, or if the finiquito is issued and there are things that you don't like about the finiquito, or if the authorities do not provide an answer within 3 months, you assume that this has been constructively rejected, and then you can go to the tribunal. All of this to say that along these lines of thought, it appears that the bottom line is that the tribunals have said that this is an administrative act. Otherwise, we wouldn't understand why I have the possibility of filing an annulment proceeding. Okay, so according to that case law, the finiquito is an administrative act that is different from rescission, and that in accordance with Mexican law, this could be appealed in a different manner than the appeal that we have in the case of a rescission, or that there would be a res judicata objection. Or is the finiquito related to the rescission and you have no way to file anything before the Mexican courts? Your point is very interesting. I said that of course I'm forgetting about the administrative appeal or the administrative remedy. I know that I can put that to the authorities that are going to decide that, but if I want to have access to the annulment proceeding, what I need to do is to challenge a final decision in connection with an administrative act. So there's only one rescission proceeding, and that ends with the issuance of the decision on rescission. So there's a different administrative proceeding that has to do with preparing the finiquito. Administratively, I have a very short period of time to submit the complaint. I only have 30 days, as a general rule, to file a complaint. So I cannot wait until I have two decisions, one in connection with rescission and one in connection with the finiquito. Once I get the notice of the rescission decision, then I have 30 days. If I have a constructive rejection of the finiquito, then another term is going to start running so that resolution can run because of its own merits. Each lawyer may have its own playbook. They can try to submit a new complaint and that is consolidated with the first one, or I can actually have standalone procedures that are separate. You have different motions for that. But this is an issue that has to do with procedural strategies. Now, to answer your question, if these are two administrative acts, well, not necessarily, but they can coincide in the same case. My question, I thought, was relevant. Perhaps I am mistaken, and the parties will correct me. As I said, I think with the finiquito, it is the first time that we see a dollar figure of the amount related to the penalty for administrative rescission under 663. This was a principle that was included in the contract, but no figure was attached to it. Apart from the fact that the amount of the finiquito was to be defined at the meeting held in 2018, I think it was May 2018 in Villahermosa. The finiquito is the first document, and it may be a contractual or administrative document, that establishes the amount. So I thought it was relevant for me to know about this. I'm sure that the parties perhaps have disagreeing opinions, but I wanted to see how this was addressed, because this has to do with the quantum of the penalty and the amount that is going to be charged to the Dorama bond. I think this is almost my last question, and it has to do with the termination of the civil and administrative proceedings for 821. In connection with the civil proceeding, you have provided Exhibit 37, and you have shown the fact that the claimants dismissed the cases, Philip Resources, Drake Mesa, and Drake Finley. And this is relevant because that dismissal also includes Drake Finley. Drake Finley was the one that signed the waiver to challenges very recently. in connection with the civil proceeding, or rather the administrative proceeding, no waiver existed there, but the ruling by the tribunal was not challenged by the claimants, and then the judgment became final. So, looking at the res judicata effect and the doctrine of estoppel, let me ask you, Drake, Finley, Mexico, according to Mexican law, could it reopen a proceeding in connection with 821 using a cause of action that is similar to the one that it is invoking in this arbitration? Let me see if I understand your question, Mr. President. You're asking whether first, in the civil arena and then in the administrative arena, Drake Finley could file a new case before the Mexican courts looking to get the same thing that it sought to get in the other proceedings, or what it's looking in this arbitration? Well, what it's looking to get in this arbitration. In NAFTA, as you know, there is a fork in the road provision. Before you go to arbitration, you have to present a waiver. The other two presented their waiver, but Drake Finley didn't. The claimants are saying that this is a piece of paper that has no relevance, but the respondent thinks that this is relevant and it deprives the tribunal from jurisdiction. So that waiver, from the point of view of Mexican law, would that waiver be absolutely redundant because of res judicata of the administrative proceeding, and because of the doctrine of estoppel, because Drake Finley already provided a waiver in the civil proceeding, then one could understand that Drake Finley has waived its right, or it cannot file new proceedings in Mexico because it let the administrative case lapse and it provided a waiver in the civil proceeding. Let me share with you my viewpoint. I did not conduct that analysis in particular for the following reason. The subject matter of the expert opinion has to do with analyzing the cases put to the civil courts in Mexico. I have not analyzed the purpose, the cause of action, or the parties that are the complainants in this arbitration. So it is a little hard for me to say whether a claim under this arbitration that I have not analyzed, I don't know what the specific claims are, I don't know if that could be put to Mexican courts. My comment, of course, is not binding, but you said that there were a number of dismissals and the civil proceeding of 821 concluded, and there was also a waiver. We saw one of those waivers on the screen in the presentation on Monday. I think that it would be complicated, to say the least, for them to be able to submit a new civil claim before Mexican courts. My comment is going to be along very similar terms. In general terms, I can say that just like in the civil arena, ever since the direct amparo was decided, the issues of legality related to the claim, those became final. This special appeal is innocuous, but in general terms, I can say that those things are now res judicata. I do have an easy question. It has to do with paragraph 48 of your first report, and there was something that struck me.
The system in Mexico consists of, bueno, ya está entendido, a federal administrative court, which is a specialist court within the executive branch. Cuando hablamos de esto, no estamos hablando.
When we talk about this, we're not talking about a different court, different from the TJFA, right? Excuse me, what are you saying, sir? I'm looking at 48I, Roman numeral I.
Which is a specialized court within the executive branch. ¿Sí? Cuando hablamos del...
When we speak about the Federal Administrative Court, the TFJA is an administrative court that is not part of the judicial branch, but of the executive branch. It is similar to what you have here in the States. I think there is an international court of justice for commercial matters that is part of the executive branch. Well, in Spain it's very different. I didn't know if this was a typo. In Spain we have administrative courts, but they are tax courts, etc. But administrative adjudicatory jurisdiction, and that's part of the judiciary. But apparently this court is under the executive branch. Well, this is like the fiscal court that they had in Spain, and that's how it started. Okay, that's all for me.
Floor to Alain. Alain.
Well, thank you. Again, I am again a general remark, but to which you are welcome to answer. Honestly, I am a bit concerned that several times when you are asked questions, you say, "Oh, it was not the scope of what we were asked," but I have tried to, I don't remember having read the precise scope of what you were consulted upon when I looked again at the beginning of your first report. You say on various issues, but you don't say that it was really specific to one question or another. So I just want to know, because sometimes I have the impression that you escape the questions on something which does not appear in your report.
Gracias, señor.
Thank you very much, Mr. Co-Arbitrator.
I was answering in English or Spanish.
Up to you.
En español lo habíamos hecho. El párrafo 20.
Okay, we said in Spanish. Paragraph 20 of the first report says that the purpose of this report has to do with highlighting some of the procedural violations and that impacted in the administrative and civil proceedings against against PEMES by the claimants. And this is the purpose of this report, to examine the court files, although there are administrative files too, and to identify some of the violations. And this is what we did summarily in our presentation today. My apologies if it seems to you that there are certain points that we're not addressing. We know how important our answers are to you here. If someone asks us to provide an opinion on a certain issue, we listen to the potential client, we meet with them, we assess the situation, we see what the precedents are, what the law says, and then we provide a specific opinion as to what we believe applies to the case at hand. apparently there are some issues that are related to in the report, but if these things were not analyzed by us or studied by us, I think we would be doing a disservice to the tribunal if we provide an answer that we think is the right answer, but it is really an answer that requires a deep analysis of the regulations, the applicable case law, so that we can provide an illustrative answer to the tribunal. So we studied these case files. We presented that to the tribunal. That was the request that was made of us in connection with the scope of our reports.
Fine, well noted. This was more related to some question by President Gonde and some of my previous questions, but now I will be more focused on what you wrote, so it will be more clearer that it was inside the scope of your study. Well, my first question might be very related to what Mr. Conde asked you just some minutes ago. At paragraph 105 of your first report, you say that claimants file their claims, so it's apparently you mean the same claim, it's in the singular, before Mexican courts, civil and administrative, respectively. Do I understand it well, saying that it was the same claim which was put to both administrative and civil courts?
Está en lo correcto.
You are correct. There were claims that were submitted to the Federal Administrative Court and to civil courts, but it's not the same claim. It wasn't the same claim that was submitted simultaneously to both jurisdictions. If we look at paragraph 106 onwards, we are going to see that we describe there the claim for the payment of certain obligations, and that went to the civil courts, and of course progress was made in those proceedings. Mr. Mesquita, of course, will explain this later, but when the administrative rescission of the contract was established, that administrative act was the subject of the administrative proceeding. These are two things that did not begin simultaneously, and they challenge different acts.
Sí, nada más se vieron por.
They were seen along several lines because civil requirements in the first proceeding were different from the ones that you have in an annulment proceeding. There you are just trying to annul an administrative act, and in this assumption it's just rescission regardless of other types of claims that could be of a civil nature and that were part of the other proceeding that Mr. Zamora just referred to.
Understood that, but this sentence seemed to me to be rather ambiguous. Now, there was long proceedings after you signed the civil court, where you insisted that should be the civil courts and not the administrative court. But apparently you seem to agree, and I think the expert for the respondent does agree also, that there was no definitive or clear precedent to choose one or the other. Is that right?
Eso es correcto.
That is correct. It doesn't mean that it is okay. What you are mentioning is fine, meaning that there were a series of claims, civil claims, and that triggered a discussion about different levels in the three civil proceedings as to which one was the forum, or the right court to hear those proceedings, and as to the petition to be heard in a judicial proceeding, the one presented by the parties to that case, we saw that in the civil case 803, it was determined that the courts that had jurisdiction were the civil courts. After 3 years of discussions, it took 3 years for the civil court to say, yes, it's us, the ones that have to make that decision. In 804, it took a bit less than a year where it says, no, it is not the civil court, rather the administrative court. And then also this added on to the conciliation stage. All of the proceeding for 804 was sent to administrative court. In 821, which had an arbitration agreement, that is where the first instance court, the district judge, in their first decision sent this to the parties to the arbitration, and that triggered the discussion as to whether that was civil or administrative in nature.
Now, I know you were not counsel for the claimants, but would have it been totally absurd to, after having a first decision by the civil court saying, no, we have no jurisdiction? No problem. Was it totally unthinkable, or totally or partially or not unthinkable, for the claimants to say, okay, the civil court has said that it is not competent because it is administrative. Why not go immediately to the administrative court, better than keeping going again and again to the the other steps?
I think I'm going to have. Voy a darle la primera parte de la.
I am going to offer the first part of the answer, and then my colleague may supplement my answer. First, it is not my practice, as we said in the U.S., with the benefit of hindsight, to see which was the rationale and the parties in those proceedings to make the decisions that they made, and the strategic decisions in each litigation have a justification to determine the pros and the cons, and I am not attempting to opine on the various elements that the decision makers took into account. But I think that a potential risk in connection with what you just mentioned, and here my colleague Mesquita may add to this. Let's think of 803, whereby 804, in which a week or 10 days after the claim is brought, the judge decides that it is not the civil but the administrative court the right one. Mr. Mesquita may correct me if I am wrong, but if the parties at that point pick up the papers and move over to the administrative court, I'm not sure the impact it would have. We would need to analyze the effect, the impact of leaving that decision final. And second, once again, as mentioned, to answer one of the latest questions by the President, the administrative tribunal and the federal civil courts belong to various powers, that is, the executive and the judiciary. That decision by the district judge is administrative, and it does not bind the administrative court. That is to say, one could go to the administrative court, and the administrative court may say after 2 or 3 years, this is not administrative, we need to go back to the civil court. So there was no guarantee, so that instead of fighting for the cases to remain in the civil courts and not to move over the administrative, or the other way around, to have the civil courts accept them. I don't know if that would be an option.
You take the floor. No.
Claro que sí, gracias.
So just before you take the floor again, I want to be clear. I didn't ask whether they were the counsel for claimants were right or not. My question is, was it thinkable or possible? I don't want you to try to antagonize your colleagues. Don't worry about that.
Lo que yo decía justamente era, a ver,
What I was saying is that there are always many opportunities or options, and in the proceedings there are many decisions to be made. What happens if I do one thing or the other, A or B? And what I'm saying here is that if at that point with 803, 804, the parties had accepted the initial decisions by the judge to reconsider the case or consider the case as an administrative case, and we don't know because this didn't happen, but it could have other negative consequences in time that would be detrimental. And if you wish, and also to be a little bit more, to be brief, I think that the expert with the Secretary of Economy also agrees that at that time there were several criteria and there was no prevailing criterion in the area of administrative contracts whenever it was civil administrative, whenever they were mixed, and in some cases it was one or the other. And even more, Pemex contracts were always beyond the application of the procurement and the works law. That is usually what we have in public contracts. Since they were beyond that and they had their own regulations, this is subject to even more interpretation. And also, to answer your question, I believe that it is difficult to know what elements were taken into account by counsel back then, taking into account this precedent to get to the decision that they got to present it first at the before the civil court and later on before the administrative court. Why did they choose that as opposed to a different strategy? That would be hard to tell.
Certainly, I have not finished yet. According to Mr. Azali's report, the average for a case to go to the three stages, I understand, is 36 months as an average. Do you think it is? Do you agree with that? Do you think it is, even if, of course, you don't have the documentation with you? Do you think it is quite reasonable number?
First, we need to consider the statistic presented in the report by Mr. Azali is a statistic that applies to only one of the cases, one of those cases, and not to several. And it's one of the circuits of the Mexican Republic. Sometimes the courts act faster than in others, and we saw it in the case of the third contract 821. From the presentation of the claim and up to the judgment, there was about a year and a half in the first instance, and then indeed it took from 4 to 6 months to appeal, and for the amparo, 2.5 years could be an average term for these proceedings. But I would also add that those 2.5 years are for the final resolution of the proceeding. And for example, if we look at 803, that is a case that after 5 years and 7 months, that is to say, twice as much, had not even reached the determination at the first instance, that is to say, appeal or amparo under the proceeding. And we should also bear in mind, as we have seen in some of these cases, for example, that we have a question asked by, I think it was the president or the co-arbitrator, when you were talking about amparos. I think it was in 821, and costs, and 2 years just discussing whether there had to be an award of costs in one of the cases, but 2.5 years may be average for some of these proceedings in all of its instances.
It was really for an average, and just because I thought that we had something to evaluate, but I agree that this is certainly more statistic than law, and law is not always mathematics. This I agree. Again, another question, probably more to Mr. Amsequita. Although I probably know the answer, but at the end of the day, I would like to have a clear yes or no answer. Since you have very attentively, apparently, reviewed the proceedings, I don't know if it was supposed to be very wide or not, but is there at any point before the administrative court was this famous article 15(1)(r) invoked? Does it appear at any time in the proceedings for A21, of course?
Para el 821. Nada más para aclarar su pregunta.
To clarify your question, I think I understood that you said whether you had seen it before the proceeding that was before the court, the issue of clause 15(1)(r). Is that your question?
O en el procedimiento.
Or during the proceeding?
Su pregunta es
Is your question in connection with invoking, if this was invoked in the proceeding before the tribunal, the existence of clause 15(1)(r), or is it before the annulment proceeding, whether...
Before the tribunals, okay, in the prologue.
Okay.
This is not explicitly indicated in the claim. This is not invoked. Paragraph R is not invoked. Clause 15 is mentioned. Now, what I was told is of the existence during and after that proceeding, that it was something that was communicated to the tribunal, that is to say, the specific existence of subparagraph R under clause 15.
On subparagraph R, but the answer is no, it was not explicitly, but 15(1) was mentioned. This is your answer, and maybe I could add to that, and R is part of 15. That's probably your answer. Okay? But I really wanted to get rid of that, to know yes or no, has it been specifically invoked or not? Your answer, I think, is rather clear-cut, so it's okay with me, at least for my question. Of course, I cannot avoid to say a word on this incredible practice in Mexican proceedings of visiting the judge. We can always say that it seems to us to be extravagant, but it doesn't help. What was very interesting this morning was an answer, I think, by Mr. Amsequita. Sorry for your name. You said that. I noted, because I was really interested at 9:05 this morning. you said the other party has to be present. Do you maintain that? 9:05 this morning, 9:05, 11 seconds. You said the other party has always to be present. Is that the case or not?
No, y discúlpeme si no.
I apologize if I wasn't clear. When I referred about these meetings with the judge, I said that even though it is common throughout the litigation in Mexico for this to be morally or ethically acceptable, at least two requirements have to be met. One, I need to be authorized as legal counsel for the party. And number two, it is completely irregular to let me know what the final judgment will be. As to the existence or the presence of the other party, I don't think I was clear enough, but what I was saying is that this type of practice, this type of tradition that, and I understand, is completely irregular to you. It might not seem the regular in your law system, but we have tried to convince the Supreme Court and various courts, starting with the pandemic, that even if it is over Zoom, to have the other party also attend that. And that would imply that the courts, with these ex-party meetings between the judge and the party that are always at closed doors, and they are sometimes afraid to ask us some questions, if the other party is there, they can open up, such as you are asking us questions. For example, did you include this? Did you include the other thing? What do you think about this? So I think that was the confusion because of that comment that I added in the morning.
That sometimes questions can help the experts themselves. So your answer is de lege lata. There is no presence of the other party. De lege ferenda, you wish it were. That's your answer. And I think probably we come to my last question. I am not sure it is. If my question is not acceptable, one or the other party will tell me it's not your job specifically, but more their job. I would like to know if there are other, if there exist judgments in whether administrative or judicial courts in which a judge has substituted basis for jurisdiction explicitly a basis for jurisdiction non-invoked by a party for another one. It is it means it supposes that you are ready to answer on previous case law. If you are not, I will ask the question to the parties.
Estamos para aclarar.
We are here to clarify the scope of the question, and I think it is clear we are talking about presumptions, not under international arbitration, investment arbitration, but we're talking about Mexican courts. The judge has the power to analyze their jurisdiction, and once again, this is part of the law. If I present a criminal matter to the administrative court, even though someone doesn't say anything, that tribunal is going to say that they lack jurisdiction. Or if I present a family matter to the court, a court that does not hear, for example, if I present it to one that has to do with business, with a commercial court, then that tribunal is going to determine that they lack jurisdiction. Now, given that possibility, we have also analyzed that in the exercise of that power to analyze the jurisdiction and settle it, there are some limitations, and in some of the civil judgments. We have seen some of the criticism as to how in these proceedings the courts have used their powers in the civil area.
We said this morning, you cannot make any analysis without having in mind the legal background, including the case law. So my question is really, is there case law where a tribunal is, I go to the civil court for you, and administrative court for your colleague, and I say, I base my claim on Article X of that law. The tribunal says, no, I have no jurisdiction on this basis, but I have a jurisdiction on Article Y of that law or of any other regulation. I would like to know if there is a leading case or leading cases for which the answer is yes, you can substitute the argument. The tribunal can substitute its own argument to that of the party, whether on the substance or on the jurisdiction.
Perdón, simplemente quiero.
I just want to understand your question. The issue of jurisdiction, and if I am not answering, please let me know, is not based on the articles that a party may refer to. Let's imagine, for example, a commercial court. There is a dispute between two companies due to a supply contract. The jurisdiction of that judge is determined by A. And they may say, you need to understand because of law X, that is one that refers to criminal judges. If in that experience, a judge would not resolve the jurisdiction based on reference to what is presented by the claimant, but they would analyze the jurisdiction, for example, such as in the appellate court, based on an analysis of what is being claimed. And if the claim is including topics, disputes, or facts that are within the jurisdiction of the commercial judge, that is to say, that has that under their jurisdiction, that would be accepted independently from the articles where the party has tried to support the jurisdiction of that judge.
I go to a civil judge. I would like also to get an answer on the administrative level, but we are in civil law. Let's go to a civil law judge. I come and I say, well, what PEMEX or PEP anyway did is contrary to Article X of law of that law of 2005, and the judge said, no, it is not, but it is contrary to Article Y of another law. Is that possible? Are there leading case law on that? Because you said that after all now your court seems to apply the stare decisis more than the pure civil law system, which doesn't know of any precedent. They say it's not true, but they say.
No tengo en este momento.
I do not have the availability to look at that precedent, but I am sure that we can find it. And I would start with our own constitution, our highest law that reflects that the courts need to apply the law. Therefore, in the example that you are mentioning, if I tell a judge this contract breaches Article 35 for X reason, the judge may say that if that cause of action, I apply the law. It doesn't breach 35, but it breaches 38. So this could be done by a civil judge in Mexico, in my opinion. I have a similar explanation for administrative courts, and mainly with higher emphasis in the administrative courts. In the administrative courts, the authorities may only do whatever is allowed by the law, so it is easier for an administrative court to review whether, based on the articles cited by the authority, they are sufficient to solve something. And also, the same applies to an administrative court. The administrative court reviews under its own organic law whether the petition, what is being requested, could be heard by that court or a different one. For example, when we are talking about the unconstitutional nature of an administrative law, the court may be administrative, but it doesn't mean that it will hear some constitutional issues, even though it is related to administrative subject matter. So that may be a different jurisdiction. I don't know if I answered your question.
Apparently, in this respect, your system is very close to my national system, even though I don't know my national system very well. Thank you very much.
You're welcome.
Antes de darle
Before I give the floor to my colleague, allow me to go back to the last comment that I thought it was in passing, but which might have more relevance than the one that I thought. We go back to paragraph 48, and if you wish, the next page of your report where you have that pyramid with the various steps, and it is clear now that the bottom of that pyramid that we have there is the administrative court that is not part of the judiciary. And I understand that the next step that is gray, that the next segment, we're talking about federal administrative courts and or administrative federal circuit courts. They are part of the judiciary. So let me give you some context to let you know where I'm going. In the presentation by Ms. Muyon from the United States State Department, we saw such a demanding standard that has to be met by the arbitral tribunals to be able to issue a decision against the judiciary of the country in question. Since I had not established the difference between judiciary courts and beyond the judiciary, courts within the executive and beyond the executive, I thought that we were talking about the difference that an administrative tribunal should bear in mind when analyzing the various judgments throughout the democracies.
So the judicial branch always demands a sort of respect, and one must presume the absolute legality, regularity, and well-founded nature of the decisions of the judiciary, and only if there is some very striking defect that turns out to be repugnant for legal mindset, as is said, a court could have grounds for moving away from that view. But I would tend to think that even though all administrative courts, well, that the judiciary owes a deference to the court, is owed deference, and I would think an arbitral tribunal in particular would have to give deference to courts that are in the judicial branch, and perhaps less so in the case of decisions of tribunals that are under the executive. That's why I'm interested in this issue that has come up. And I think there was a misunderstanding of mine of your regarding your report. Let's recall the history of the administrative jurisdiction. Well, originally it came up in France, and it was under the Council of State, which was a pure administrative body. It was not even a court. It was a Council of State that was practically a department of the public administration. Then separate courts were established, but still under the umbrella of the executive, as is still the case in Spain, in tax-related matters, in Mexico as well. And then I go to the third step, which is the creation of a contentious administration jurisdiction as part of the judiciary. In Spain, there's a famous study that talks about the evolution of the administrative courts. So it's clear that in the case of the Federal Administrative Justice Court that led to that decision of 4 October 2018, which you attach as document 39 to your report, RZ 039, this is the judgment of an administrative court. And so I have two questions. First, what practical difference is there in Mexico between a court being administrative or being rather under the executive or part of the judiciary? Is there some difference in terms of how judges are selected? Is there some influence that the executive has over administrative courts that are part of the executive that is different? What practical difference beyond the labels and beyond the budgetary implications between a court that is under the executive and a court that is under the judiciary in Mexico? It's much easier for a court, for an administrative court to publish names of potential judges than in the judiciary. There's a more institutional way of selecting members of the federal judiciary, beginning with the members of the Supreme Court who are proposed by the executive and ratified with by a supermajority in the Senate, to judges in multi-judge courts and single-judge courts, district courts, who normally must take an exam before, once having been in the judiciary. The mechanism is more institutionalized to rise in the judiciary because of the total independence of that branch of government than a court which legally is autonomous. And I don't want this to be misinterpreted, because the court has grown and it has become an administrative tax court because of its great reputation. It's interesting that it seems to operate better than the federal judiciary. But it's much easier, as you'll see, or as you can imagine, for there to be political quotas for designating judges who would be part of a chamber or even the superior chamber of the court. There's more involvement or intervention. I can't cite any figures, but the press has realized that such negotiations take place, especially with each change in administration, how each party, depending on its strength, among other positions that they try to take possession of, are the federal administrative judges. Nonetheless, I think that in large measure they try to cover those political quotas with people who are more or less capable, even though there might be a certain political burden. I don't know if I've answered your question. Why does that not happen in the judiciary? The system for promotion of judges is completely insulated from any political influence. Judges, except for the members of the Supreme Court, have they rise through the judiciary. They begin as clerks. They end up having to take competitive exams. So if a district judge position opens up, there might be 50 young people already working in the judiciary who come forward to take an exam, but there's only a place for one. And in this way, they start rising in the salary in the staff structure, except the members of the Supreme Court. Not all of the members of the Supreme Court, and at this time there are only 11 of them. They are not all in the judicial career service. The majority arrive through a slate presented by the executive, and they need to win supermajority backing in the Senate. So there's an initial three-person slate, which is presented to the Senate, and they need to get the vote of 2/3 of the Senate. Well, if one gets such a vote, then they can become a member of the Supreme Court immediately. Now, if nobody wins enough votes to have the supermajority, then the president can send a second three-person slate. Now, if no one gets a supermajority, the supermajority required, then at that time, then the president can directly appoint the future member of the court. So as you realize, there's more control because two other powers or branches of government become involved, the president and the Senate. So the supplemental question is if you could refresh my memory. I understand that the judgment of the Federal Administrative Court was handed down by a court that is under the umbrella of the executive. I also remember perfectly well that there was an amparo proceeding before the Supreme Court, but I understand that in the case of any amparo, only entries of constitutional rights would be heard. So there would not be full jurisdiction. I don't know if they use this expression in Mexico. Rather, it was limited to those potential violations. But in addition to the amparo before the Supreme Court and the decision of the Federal Administrative Court of Justice, what other courts were involved? Were they executive or were they judicial, properly speaking? And if it's in the record, I should know it by heart, but at this hour of the day, I've forgotten. In 1821, we began with there was a resolution by one of the two sections of the superior chamber of this court. It wasn't just any regular chamber, as was the case in 804. Now, as against the resolution that was issued, judgment, if it's a court, or any other final decision in proceedings such as this, against that one may only bring a direct amparo. Now, in the federal administrative courts, there is no right to appeal as there is in civil courts. There's no a second instance. In administrative matters, we could say that whatever the Federal Administrative Law Court says is the final decision. So much so that one may bring a direct amparo. For example, in a civil matter, I must first exhaust the appeal before I can bring an amparo. I have to exhaust the appellate level in order for the judgment to be considered final. In federal administrative matters, that's not the case. As against a ruling by the Federal Administrative Law Court, I can bring a direct amparo. And in a direct amparo, I call into question the unconstitutional aspects of the ruling itself, or any unconstitutional acts that might have been committed in the proceeding before the court, or I can attack or challenge the unconstitutionality of provisions that are applied in the judgment itself. Now, the principle of deference that you mentioned, we don't normally apply in these cases. We leave that, for example, as between the federal judiciary when it comes to regulatory bodies. Technical issues, the administrative court doesn't normally tell the regulator, telecommunications, economic competition, intellectual property, how to resolve the issues on the merits. They merely say, I remand it to you so that, mindful of these procedural aspects, you should resolve what the law, where the law leads. Now, as between the federal judiciary and the federal administrative law court, there could be something similar in principle. If there are procedural flaws, however much the multi-judge court, for example, in this case, if it was in agreement with the judgment on the merits, it could grant the amparo for the purpose, well, instead of deference, it's an amparo for the purpose of the court curing certain procedural flaws, and there may be a new ruling. This would be with full jurisdiction or limited to certain issues already being covered by res judicata, and others could be reiterated by the court itself. If I've understood you properly, Mexico, in the case of administrative acts in the administrative jurisdiction, there is no appeal within the judiciary which, with full jurisdiction, can review an administrative act or a judgment by the Federal Administrative Law Court. For example, when it was the Fiscal Court of the Federation, this court did have an appeal. The first was a regular chamber of the court. The second was the superior chamber of the court. And then it was then after that would be a trial on constitutionality, which is what the direct amparo is. But some time ago, as a matter of procedural economy and speedy justice, we did away with that second instance or appeal within the tribunal or the court itself. So what would the thing to do is that a multi-judge court would analyze the issues on a direct amparo, which is the federal judiciary.
So now we reopen the questions from the parties, and now is the turn of the claimants. You may raise questions directed either in redirect to what respondent asked the expert, or related to questions from the tribunal, but not to open new issues which have not been discussed so far. So, Mr. Porter.
Thank you. Daniel, in the administrative court claim, could you explain exactly which clause, was Clause 15 raised by both parties before the administrative court in your review?
Based on my review, if you are referring exclusively to the claim, the legal action, then mention was made of the clause. I believe it was 15.1. Subsequently, in the answer to the complaint, the authority also mentions clause 15.1.
If there was an extension of the complaint or some subsequent complaint, and that pleading mentioned 15.1R specifically, how would that have changed your analysis in this case?
You are saying, let me see if I got your question. If there had been an extension of the claim that made express mention of paragraph R of Article 15, would that change the gist of my opinion? Is that your question?
Yes. If there would have been an extension of the complaint or subsequent pleading that had made that specific mention, would that have changed your analysis?
Señor Presidente,
or how?
La demandante está haciendo preguntas en torno a un documento.
Mr. President, the claimant is asking questions about a document that we haven't seen and which apparently the claimant wants to introduce one day once it gets it. That was not part of the cross-examination by the respondent, nor was it raised by the tribunal. The experts would have used that in their presentation or on redirect, which the claimants decided not to proceed with.
Okay.
Mr. Pillay pretty much specifically asked him that question and then made him go on the record about that specific question of whether he had seen it. So I was just, before anything else happens, I wanted to know personally and for the benefit of the tribunal, what effect it would have had. We have him here on the record, and we can ask him that question. We can get his insight. He is the one person in this room that has administrative law experience.
Okay, go ahead.
So if that specific clause had been raised in some subsequent complaint, extension of the complaint, or pleading, how would that have changed your analysis in this case?
As regards the initial complaint, it would not have changed my opinion, but a subsequent mention in an expansion would have further strengthened the opinion that I had regarding the complaint brief.
Thank you. No more questions.
Señor Bonfilio tiene la palabra.
Mr. Bonfilio has the floor. Thank you, President. I was able to hear, stemming from the answers you gave the tribunal, answers regarding questions about the clauses in contracts 803, 804, and 821. That means that you, Mr. Amezquita, did analyze the contracts when you drew up your reports. Is that correct? Just to add one point, 803, no. The proceedings in 804 and 821 were the subject of my analysis. And maybe I wasn't clear. Let me apologize. Based on the responses that you gave the tribunal, it's my understanding that you analyzed all three contracts that are the subject matter of this arbitration. Is that not correct? No, I did not analyze all three contracts. I heard you answering questions about the finiquitos of the contracts. That means that you did analyze the finiquitos of these three contracts for drawing up your reports, correct? No, I was answering a generic question that was put to me by the co-arbitrator. I take note. We have heard the claimant say a lot about a brief of arguments, which I think they've made mention of. It's my understanding, based on what the claimant says, that there is a brief of arguments that was supposedly presented by Drake Finley in the 2017 annulment proceeding. I'd like us to please go to evidence that is in the record, and that is Exhibit R92.
Y para su beneficio.
And this is the federal law on administrative procedure. If you could give us just a second, you'll see it in just a moment.
May I take the occasion to say something? Quite often this morning I saw documents in Spanish. I tried to find the translation in the file I got, but they are not complete. And this is in particular true for 92. So if any of you refers to documents which is not translated into English, please read it for the benefit of the interpreters and my benefit, because otherwise I follow a discussion which is a bit Chinese or Hebrew or Spanish to me.
Yes, and as a follow-up, yes, for me not to forget, probably the tribunal might ask the parties to translate into English some selected number of exhibits which are only in Spanish, and which might be of interest for the consideration of the tribunal as a whole.
Con el mayor de los gustos podemos.
We would be pleased to translate any document needed, and we'll undertake that exercise now. As I was saying, I would like you to take a look on the screen at R92, which is the Federal Law of Contentious Administrative Procedure. On the screen, you'll see Article 47. I'm going to read it to make things easier and for you, and also for the transcript. Halfway through, it says, and you'll see it highlighted in yellow, the arguments presented in proper time shall be considered when the judgment is issued. Said arguments may not expand the dispute as set in the agreements or decisions admitting the claim or the admission of the amendment of the claim, as the case may be. Close quote. Do we agree that Drake Finley did not make any argument regarding Clause 15R of Contract 821 in its complaint brief, which began the 2017 annulment proceeding? Is that right? No. I've asked that question, and Professor Pele asked that question. Please think through your answer carefully. To begin, let me conclude my response. And second, I am very much bothered by that threatening tone. Mr. Amesquita, you are here to respectfully answer the questions by the attorney who is conducting himself with notable professionalism. So please avoid such statements. Yes, sir. What I said is that, in effect, there was no express mention of paragraph R. Indeed, when I was speaking a moment ago with the co-arbitrator, we said that, well, based on what I understand of the complaint and what I said in my report, such mention of subsection R was not necessary. By simply mentioning Clause 15.1, well, that it was more than sufficient for the court to be able to expound on all of the grounds for annulment, or rather for rescission. Interpreter corrects himself. If what you want me to say is that it would not be possible to take into account subsection R because subsection R was not expressly mentioned, that is where I say I don't agree. The express mention or the transcript of subsection R in the complaint brief does not exist. But for me, and this is my opinion, it's not necessary. It's more than sufficient if I cite Clause 15.1. Thank you for your explanation. I understand that Drake Finley did not present an amended complaint in the 2017 annulment proceeding either. Is that correct? I don't know of, nor did I see any amended complaint. If Mr. Bonfilio will allow me, now that we have this article up on the screen, there the key question is you cannot expand the dispute. This is a reference to changing what is sought by bringing the complaint. It also it impedes adding additional evidence without modifying the causa petendi. Well, the specific topic here, when it mentions the dispute, is what is the prayer for relief or the relief sought. This is what I'm asking the court to rule on, and it's made up of these the elements, the resolution that has been called into question, the complaint, any amendment if it is, but we're simply talking about the relief sought. In general terms, one cannot present more evidence after the complaint, the answer, and the amendment, if there is one, unless it is characterized as supervening evidence, generally. I understand, and I'm sorry, Mr. Bonfiglio, for interrupting you, but I thought it was very relevant to figure out the scope of the expression expand the litis. Then we need to understand the spirit of this article. Based on the article that we see on the screen, Article 47, one cannot introduce new arguments in an annulment proceeding by briefs if those arguments were not put forward in the complaint seeking annulment. Is that right? That is correct. You cannot add more arguments or concepts or bases for challenge through arguments, for example. Thank you very much. During the questions by the tribunal, Mr. Sternman and the President asked some questions about litigation related to Contracts 803 and 804 and the briefs seeking dismissal. Let me ask just for help on a couple of points. With respect to Contract 803, Mr. Zamora, the relevant proceeding was Civil Proceeding 75, 2015. That was heard by the 11th District Court, correct? Excuse me, could you repeat the question, please? The relevant proceeding in respect of 803 was 75/2015, correct? Yes, that is correct. And for Contract 804, the relevant civil proceeding was 120/2015, and in the area of administrative law, it was the annulment proceeding of 2019, correct? Well, except the last part says on 2016 was not administrative, it was civil as well. But yes, it was those two proceedings, civil. I'm sorry if I wasn't clear. Thank you. In proceeding 75/2015, MWS put forward several claims against PEP, including a claim for $13 million plus other items, correct? These are identified in the report and in the complaint. That is what they claimed. And as regards the other, 120/2015, MWS and Bissell brought a claim against PEP with several claims, but including approximately $22 million. Is that correct? The claims are identified in the documents. Well, this is relevant because of another procedural question. The lapsing of the instance is a procedural rule by which a proceeding can be terminated due to inactivity of the parties, correct? Formally, yes. However, I must also note that in the case of the litigation 803, which you've identified as 75/2015, in that case, prior to lapsing, there was a brief in which the moving parties abandoned the claim. Thank you. As regards the discontinuance, the parties stopped acting for a certain time, and as a result, the proceeding came to an end. Correct? I'm going to speak conceptually, not regarding that. This rule on caducidad de la instancia or discontinuance is provided for by Mexican procedural law, where inactivity of the parties leads to the end of the proceeding. And when one party presents an abandonment and it's not been ratified, it's not deemed valid until it's been ratified by the court, right? For a purpose of the practice in Mexican law, and there are different views of different courts, but on occasion it is asked that some abandonment be ratified so for the purpose of going before the court when the person needs to be there physically so they can say, I signed that memorial, even though it's all been completed and presented to the court and received by the court. My question is, do you have any knowledge of any of the proceedings in relation to contracts 803 and 804? Well, did this discontinuance due to procedural inactivity operate? No, I don't agree. You mentioned two proceedings in relation to 803 and 804. 804, you'll recall from the narrative I offered this morning, is a case in which the judge of the trial judge and later the higher courts rejected the jurisdiction because it was administrative matter. When this ceased to be discussed in an amparo, there was no discontinuance. There was never a proceeding, and it was referred to the administrative courts. Let me repeat my question. Do you have knowledge that in some cases related to contracts 803 and 804, some adjudicators declared that the matter was discontinued, at least in the civil part that I reviewed? I don't agree because, as I indicated earlier, in 804, there was a procedure in that, and there is no declaration of discontinuance there. I take note of your answers, Mr. Zamora.
Señor Presidente.
Mr. President, just 1 minute, please.
Señor Presidente.
Mr. President, we have no further questions, and I would like to apologize to the experts if they think my questions were bothersome. You don't have to apologize. You were acting in a very nice manner.
Disculpe, señor presidente.
My apologies, Mr. President. I would like to apologize because I felt that the statement was a threat, and I would like to apologize to you, sir.
Probably I should apologize for something as well. Just a question while we have this on the screen. The translation, which was the interpreters do as quick as they can. So maybe there could be a nuance in the translation. The translation says of this Article 47, the end of it, the arguments presented in proper time shall be considered when the judgment is issued. Said arguments, this is what interests me, said arguments may not expand the dispute asset in the agreements or decisions admitting the claims or the admission of the amendment of the claim as the case may be. So my understanding of this, again, maybe the translation is not fully precisely accurate, but I suppose it means it's easy to understand, at least as Caesar, but I want to be sure that it is what it means. It means, from my point of view, that you cannot change the expansion or the scope of the dispute, but you can change the arguments. I think this is very different, and honestly, I try my best. Spanish and French are proximate, but sometimes when you do law, you cannot be too much approximative. So if it is, I think it changes things, whether you cannot change the arguments or you cannot change the scope of the dispute. These are, for me, different things. I don't know yet what I could conclude from that, but I think I would like to be clear on that.
The interpretation of Article 47 makes express reference to this word in Latin, litis, the dispute. And this article hasn't really been developed by legal scholars, and the only thing we can do is to interpret the language of this article. This is a procedural rule, so it admits a number of interpretation. When we use this word, litis, that is to say the case or the dispute, the litis is made up of the challenged act. For example, the administrative rescission document for 821, the complaint, that is to say, what I'm asking against that rescission, the answer by the respondent authority, and it only has one limitation, which is that it cannot perfect the justification that should have been present in the challenged decision. And then there may be reasons to include additional items in the complaint to expand the complaint. So the respondent authority may make known to me acts or events in the answers that were not known to me in the past. The law affords the opportunity to me to include additional items in my complaint and also to include other issues that are going to be taken into account in the dispute. This is what we understand when we talk about how a case is developed in an administrative law case. And these are the elements that we have to interpret Article 47. For example, I cannot include new facts when I expand the complaint. Now, in connection with evidence, I wouldn't include this in connection with the complaint. I would say that I would include other pieces of evidence unless they are supervening.
You cannot include new facts, but can you include new legal arguments without changing the content or the scope of the claim?
What I'm understanding is more, if I understand your question correctly, let's see. I cannot include new facts, but I could include certain aspects that are different from the ones that were initially put in the original complaints. Is that what you're asking? That is to say, aspects that I include later on to expand on the complaint? Is that what you're asking?
I'm not sure I understand the word aspects, legally speaking.
Well, arguments, details, that
word.
Argumentos.
Okay, arguments then. You cannot put in new arguments after the complaint or the answer are filed. That's why I was using the word aspects. That's why I wanted to understand your question. The argument has been included in the complaint, in the answer to the complaint, in the expansion of the complaint. Let's see. If in the complaint I spoke of 15.1 and I never mentioned subparagraph R, And then, later on, in another brief, I make reference to subparagraph R. From my viewpoint, that is not a new fact. That is not a new argument, because the case had to do with interpreting Clause 15, independent of the paragraph or subparagraph, because those things are part and parcel of the analysis that I have to conduct as a court of a clause. The contract says that the clauses must be interpreted one against the other, specifically when we're talking about an administrative law matter put to the tribunal. That is why it was very important to introduce a new argument, for example. For example, I didn't say anything in connection with PACMA. And all of a sudden, in a subsequent brief, I say, okay, I agree with what the respondent authority said in connection with the PACMA. That is a new argument. But if I develop an issue that I already included in the complaint, I don't think that this would go against this provision. You can have your own opinion, evidently, and this also depends on how you put this argument in your words or aspect in my words. I don't know if I've answered your question.
I am not sure that I would agree with you concerning PACMA. I think that if it was not in the complaint. Well, I'm not sure that I would agree with you on PACMA, because precisely I think if it was not included in the complaint, then you expand the dispute itself. It's a new request from my point of view. But this is not so much what I had in mind. What I had in mind, precisely the contrary. I lodge my complaint. I base myself on 15.1, as you like to say. But suddenly, I find that I have Article 102, which, after all, supports my view. Can I bring this before the tribunal and say, oh, 102 is also confirms my argument? This is why I prefer argument than aspect.
What you were saying to me is that you consider that an argument is a petition made directly to the tribunal. Court, please rule on this matter and say that under R, I am right. I put to you 15, and you should analyze whether there were grounds for rescission or not. But then I say, specifically, say to me that I am right under R. And that could be a violation, because I'm telling the tribunal, please tell me that I am right under R. When my petition on the merits was, okay, it doesn't matter what paragraph it was. Please, court, analyze Clause 15. In connection with PACMA, that was a hypothetical. That was just an example. I haven't said that this was the case. But there is a substantial difference between asking the tribunal to tell me that I am right under subparagraph R of Clause 15, that's one thing, to judge, please review Clause 15 and tell me whether grounds for rescission have existed after you conduct an exhaustive analysis of my petition, and also looking at the suficiencia de la queja. And perhaps we don't even have to indicate a subparagraph or an article of a law, because otherwise I would be defenseless if I forget to cite a subparagraph or a paragraph. So, if what I am asking to the tribunal is clear, then my argument should proceed. Now, if I want the tribunal to rule specifically on a certain matter and say, okay, I am right specifically under R, then yes, we can be unduly modifying or amending the dispute or the complaint.
Try again, then I would give up. But no, this is not exactly what I have in mind. I am less obsessed by R than you are. Okay, I have invoked 15R, 15.1R or 15.1 but it is in my complaint. But during the proceedings, I realized that after all, Article 102 supports my argument. Can I do that in Mexican law or not? In public international law, you can. What you cannot is to say I want to add PACMA, for example. If I have forgotten PACMA in my complaint before the ICJ, for example, it's over. I will not be able to ask the court to decide on PACMA. But I would be able to say to the court, well, forget with R, which is your obsession, forget with 15.1R, but look at 102. Is this possible and in Mexican law or not? This is my question.
Yes. According to what we said this morning, I think we were talking about a dictum, which is tell me the facts and I will tell you the law. And I was making reference to that. If, without changing the arguments and without changing the facts, I forgot to include an article, and later on I find a law that has a section that strengthens my original argument, that I can do. I can say, okay, you can include this because I am not changing the complaint. I am not changing what I'm asking the tribunal to rule on. I am simply suggesting that an article that was not cited by me from the beginning, that article could be applied in my favor in the instant case.
And the tribunal could say, I don't apply R, but I apply 102. Fine.
Correcto. Podría.
Correct, yes. The tribunal could reach exactly the same conclusion in spite of the fact that I show the tribunal whatever articles that I've shown to it. Yes.
Brings your expert testimony to an end. We now need a break, 15-minute break. Then we'll have the direct presentation by Mr. Asali. My guess is that you will take some time for cross-examination of Mr. Asali, and probably the best idea would be to start that cross-examination tomorrow, so that tomorrow we do everything together, your cross-examination plus redirect plus tribunal's questions. What would be your suggestion,
Well,
Mr. Malso?
I'm happy to start cross-examination today, if you would like. Save time.
The thing is that Mrs. Fleckerson advised us that having started at 8:30, I think ideally we should be finished by 6:30. And my guess is that your cross-examination will not end by 6:30.
Hard to tell, but that's probably a safe assumption.
He's offering to interrupt. So, am I understand that you would be fine? Am I correct to understand that you'd be fine to start your cross-examination, say for half an hour or 40 minutes? We reach 6:30, and then you continue next morning.
Absolutely.
Okay. Okay, that then probably would be the ideal. So we break until 4:36, 37, and then we'll resume. Well, are we ready to resume? Señor Bonfiglio, ¿quiere decir algo antes?
Mr. Bonfiglio, did you want to say anything before the expert Asali begins his presentation? Not really, Mr. President. Simply that he will make a presentation for his direct, and we're just trying to put it up. While we project it, Mr. Asali, could you be so kind as to read the declaration that you need to make to us as an expert?
Presidente, buenas tardes, miembros del Tribunal Arbitral. Mi nombre es Jorge Asali y declaro solemnemente por mi honor y
Canal, por favor. Gracias. Disculpe. Voy a empezar, por favor. Gracias.
Interpreter apologizes, was on the wrong channel. My name is Jorge Asali, and I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief. You have the floor to make your presentation. Thank you, Mr. President. My name, as I said, is Jorge Asali. I am the expert presented by Mexico, which has asked me to make a brief presentation of the two reports that I filed in the record. I am an attorney on procedural matters, mercantile, administrative, and arbitral law. For this purpose, we've divided the presentation into 5 main topics. The administrative nature of the contracts, specifically contracts 803, 804, and 821, a brief theoretical presentation on civil and administrative procedure in Mexico, the civil and administrative proceedings that stemmed from the contracts, and the procedural violations alleged by claimants. Now, without more, the analysis regarding the validity of termination of the contracts will always depend on their legal nature. The legal nature of the contracts depends on what law applies to them. In this case, if it's the repealed Pemex law or the current Pemex law. The current Pemex law was published on August 11th, 2014, but it did not come into force until December 2nd of the same year. Therefore, every contract entered into prior to December of 2014 is governed by the repealed Pemex law. And so, mindful of the date when the 3 contracts in dispute were entered into, they're all governed by the repealed Pemex law, which is administrative in nature, as they were signed prior to December of 2014. The contracts entered into by Pemex or its subsidiaries, as we were saying, under the repealed Pemex law, are exclusively administrative in nature, which, to this date, has been confirmed both by the Supreme Court of Justice of Mexico and by the Federal Court of Administrative Justice. Accordingly, the contracts are administrative in nature and should be governed exclusively by the Pemex law, its regulation, and the so-called administrative contracting provisions, known by the Spanish acronym DACs, the DACs. Now, the administrative nature of a contract presupposes the existence of what is called the exorbitant or exceptional regime, by which public entities have special powers or extraordinary powers, such as that the power to be able to effectuate an administrative rescission without the need for a judicial declaration, that's to say, to rescind a contract. And this power derives from Article 134 of the Constitution, which sets forth fundamental principles for public contracting for the efficient use of public resources. And this regime has been confirmed by the federal courts through criteria that are binding for all. The administrative nature of the contract is also relevant because it provides for the concept of a finiquito, or settlement. This is understood as a process required by law in order to terminate public contracts. The purpose is to establish the legal consequences and scope stemming from said termination. Once the finiquito is drawn up, the only actions that subsist in favor of the parties, here it says contractor, but it really should say the parties, are those that stem from the finiquito itself. Any additional issue will be out of order, inadmissible. Now, the law applicable to contracts does not require an act subsequent to the finiquito in order to extinguish the rights and obligations. The repealed Pemex law and its regulation, as well as the DAX, provide that with the finiquito, the relationship, the contractual relationship is put to an end. Now, with respect to the courts that have jurisdiction to take cognizance of controversies derived from the contracts, prior to 2018, there were isolated, discrepant views as to which judicial authority could or should take cognizance of a dispute. There were some who thought that the conflicts should be resolved in the civil jurisdiction, mindful of the nature of the claims, and others who indicated that what was appropriate was the administrative jurisdiction, mindful of the nature of the contract and the dispute. Now, since 2018, the Supreme Court resolved through binding case law that any dispute that arises from administrative contract should be resolved by way of the administrative courts. Second topic, contracts 803, 804, and 821. In the report submitted by the claimant's experts, the content of the three contracts is not addressed. I will try to focus on the most relevant clauses in this part of my presentation. First, regarding contract 803, which was entered into 20 February 2012, it should be noted that it was determined that it would come into force from its signing and would conclude with formalization of the legal act that would extinguish the rights and obligations of the parties. Therefore, the finiquito. It had a time of implementation from February to December of 2013, which was later extended, and therein the finiquito is established in order to certify compliance of the obligations of the parties as well as conciliations within the framework of the contract itself. As we said, this contract was in force until 10 February 2015, when the finiquito document was formalized. And this is different from the time that the contract was in force for performing the work, which had already ended. The finiquito was the formalization of the legal act by which the parties concluded their contractual rights and obligations. Contract 803 from that time is no longer in force. The parties' conduct also reveals that this was their understanding at that time. In the finiquito, all balances stemming from the contract were resolved, and there was a reservation on unrecoverable costs and some other item, and therefore they were contractually impeded from bringing a subsequent claim under this contract 803. With respect to 804, I should note that the contract had a good faith and equity clause. It also established a time for the work to be done, and it had a minimum and maximum amount for the work to be done, a minimum of $22 million and a maximum of $55 million. In addition, the finiquito is established. It indicated that the term of the contract would include, once it was formalized, and only in the event that a balance in favor were recognized up until the date of payment thereof. What was PEP's obligation in light of this clause on maxima and minima? The clause does not represent an obligation on PEP to make this expenditure. The clause is clear, and there can be no doubt. It is a power, but not an obligation of PEP to issue work orders up to the maximum to the ceiling established as the maximum budget. Now, the obligation to provide a performance bond that would refer to the maximum amount of the contract does not revoke its literal terms and the obligation of PEP assumed in the contract itself. Now, in this case, Contract 804, the term was subject to formalization of the respective finiquito. Any right reserved in the finiquito would have as a source the finiquito itself and not the respective contract. It must be said that in the finiquito, no balance in favor of the contractors was established. What did exist was a reservation of rights to claim for up to 40% of the total amount of the contract and non-recoverable costs. That 40% coincides with the $22 million, which was the minimum amount of the contract. Finally, Contract 821. It has clauses very similar to those we've already discussed on good faith and equity. It establishes the time for implementation, and here I will stop for a second. The time for implementation of this contract was to run from March of 2014 to 31 December 2017, which is a relevant date considering that the civil complaint filed by the Today claimants came prior to the expiration of that contract. The time for execution of the works had yet to expire. It also had a minimum and maximum clause from $168 to $418 million, and the much discussed administrative rescission was provided for as a power of PEP. Now, this contract did not end with the finiquito that was signed, but rather because of administrative rescission by PEP. PEP decided to effectuate administrative rescission of the contract and initiated the procedure provided for by the law and gave notice thereof in August of 2017. That rescission was based on the breaches of Work Order 028 of environmental concerns. The notice without earlier indication of the domicile and other contractual vices. PEP was not required to grant any period for cure. This was a power but not an obligation of PEP. And said administrative rescission was confirmed by the Mexican courts. Now, I'll quickly touch on Contract 809, which I also cover in my reports. This contract bears some similarities to what we've discussed with regard to Contract 804. It should be noted that in this contract, contrary to those that are in dispute here, there was an effective suspension of the work due to act of God or force majeure, which caused amounts owed for unrecoverable expenditures and which were eventually paid by PEP. Now, let me underscore, this was not to execute a contractual minimum amount, but rather as non-recoverable expenditures as reviewed. Now, briefly, I would like to present a theoretical presentation on civil and administrative procedures. I would simply indicate that civil procedures in Mexico have two levels, first and second, or trial and appeal, and there will always be amparo proceedings or amparo on review proceedings for the parties to uphold their rights. Now, administrative procedures have a first instance and certain remedies within the same to challenge decisions of the person responsible, and then, depending on whether one is an authority or a regulated party, one may have an amparo proceeding or an appeal for review, as well as an amparo and review. Now, in terms of the civil administrative proceedings that stem from the contracts, first we have the civil proceeding stemming from Contract 803. This was a trial in the regular civil courts, and there were many particularities during its processing. Originally, the complaint was dismissed. Then there were lengthy claims with respect to the possible jurisdiction or lack thereof of the civil court judge, which has also been an issue in this arbitration. At the end of the road, while there was a brief abandoning the claim by the plaintiff, it was discontinued because of a failure to give it any procedural impetus. Here's a short timeline so that for the tribunals, to assist the tribunal when it comes to studying this dispute. I'm not going to dwell on that in light of the time. Next, we have the regular civil trial stemming from Contract 804. Here, the district judge first declared itself without jurisdiction, considering that it was an administrative claim. This determination was upheld by the respective courts, and it never went forward. Now, with respect to the administrative proceedings stemming from Contract 804, and this was noted by one of the arbitrators, did not begin until 9 March 2019. While it was ongoing, there were delays caused mainly by the decision of the contractors to bring complaints against other authorities other than PEP, which led to the challenge of that effort to act against several authorities. The contractors eventually abandoned this complaint in June of 2022. Now, as for Contract 821, there was also a civil trial and an administrative proceeding. The civil proceeding was presented in April of 2016 to recover payment of the minimum amount that had not been effectuated under Contract 821, as well as the unrecoverable expenditures stemming therefrom. The judge declared itself without jurisdiction and referred the parties to arbitration. Finally, in the amparo phase, this decision was overturned, and the single judge court was ordered to rule on the merits. When that happened, it absolved PEP of all of the claims against it. And the claimants did not challenge this last resolution, this last ruling, and so it was final. And here is a timeline to assist the tribunal. Finally, the administrative proceeding stemming from Contract 821. Here, an annulment action was brought against the administration of Pemex, and it was drawn out over time because of the need to get an expert report on engineering. At the end, the Superior Chamber confirmed the validity of the administrative resolution and then denied the amparo. Among other things, in this proceeding, violations of the NAFTA were alleged, which at the end of the day it was noted that it wasn't appropriate to, where there were simply rights and obligations commercial in nature, it was not proper to invoke the NAFTA. And here is a timeline for the assistance of the, to assist the tribunal. Now I will address the procedural violations alleged by the claimants. First, the alleged delays in the processing of the proceedings. The duration of the civil and administrative proceedings brought by the claimants was justified by the particularities of each case. This can be easily shown, mindful that no proceeding lasted the same length. Each one lasted based on what was presented or brought up in the context thereof. The Mexican courts have recognized that the timelines provided for in laws for a trial don't always correspond to what actually happens, and this does not make for a violation of due process. Delays in a trial respond to their complexity, the procedural activity of the parties, the motions that are resolved. In my experience, also, what also comes into play is the organic composition of the judicial body that takes cognizance of the dispute how long it takes the challenge means available, as well as the interruption of work due to COVID-19 pandemic. Now, to be specific, the regular civil proceeding stemming from 803 was delayed in part because a motion arguing lack of jurisdiction was filed. It took a long time for it to be resolved, and that led to delay in it. Now, the administrative proceeding in respect of 804 was drawn out because the decision of the moving parties to include as part of the proceeding authorities other than PEP, which led to a challenge and to the eventual exclusion of these other parties from the proceeding. As regards the regular civil proceeding in respect of Contract 821, at trial, it lasted about 18 months. Now, the procedure was not significantly set back by the jurisdictional conflict because eventually a judgment resolved the merits and PEP was absolved of the claims. And as regards the administrative proceeding stemming from Contract 821, it lasted approximately 12 months at each level, and this is normal, mindful of the workload of the courts and the complexity of the controversy. The claimant's experts also say that there was a violation of the principle of res judicata. This they consider that the district court that took cognizance of the civil proceeding violated the principle of res judicata on having declared that it did not have jurisdiction to take cognizance of the matter after its superior, the single judge court, having determined that that adjudicator did have jurisdiction. In my opinion, there is no violation of this principle. The determination was a decision prior to the appearance of PEP in the proceeding. It had not had an opportunity to challenge that determination, to have much less to be heard and overcome at trial and to be able to submit any evidence. What is clear is that once PEP received notice, it was able to argue against jurisdiction, and it also could present new arguments and evidence, which in effect it did. Therefore, there was no violation of this principle. In my reports, I set forth some examples of the application of this rule in various institutions in Mexico, such as suspension in an amparo proceeding, studies of the appropriateness of a given area of the judiciary, or supervening facts that relate to jurisdiction. The initial decisions made without a prior hearing of the other party do not constitute res judicata because they are subject to modification in light of new evidence or arguments. Now, the issue of ex parte communications has also been addressed at length in this hearing. In Mexican litigation practice, the possibility of one of the parties meeting with a judge without the presence of the other party is widely followed and allowed, and it does not constitute irregular conduct or biased treatment. Meetings with judges, even with members of the Supreme Court, tend to be common. In these meetings, the judges do not inform the litigants of what their decisions might be and of what's been analyzed in the record. There's no evidence of that has happened. The claimant's experts also argue that PEP received supposed preferential treatment because supposedly it came to learn of a proceeding before notice of it was given. This accusation, in my humble opinion, does not agree with the functioning of the judiciary because of the publication of the lists of agreements. These lists of agreements include syntheses of all rulings adopted by judicial bodies, and they include data to identify the identifying data in the procedures. There are search systems, both public and private, to which every party has access, by which a given respondent can find out about a proceeding against it. With respect to referring the sua sponte referral to arbitration, the claimant's experts state this is an alleged violation because the district judge referred to arbitration the dispute that stemmed from Contract 821 in its civil phase without any of the parties having asked it to do so. Independent of my interpretation, Article 1424 of the Commercial Code can provide for this to happen. What is clear is that any possible irregularity or violation was cured because the judgment eventually handed down referring with a referral to arbitration was replaced by another which resolved the dispute in which PEP was absolved from the claims against it and the claimants refrained from challenging that judgment.
Mention was made at this hearing about the inapplicability of the suplencia de la queja. Claimant's experts indicated there was an alleged violation to the principle of supplencia in the civil proceeding of Contract 804. This principle does not mean that the courts can take the place of the petitioner to improve or cure or present different arguments, with the exception of specific cases, such as in family matters, criminal matters, or agrarian matters. Amparos are ruled by the principle of strict adherence to the law, and this is not an exceptional case. Our case isn't. The amparo was dismissed. The amparo that was filed by the claimants was dismissed because their arguments were novel, and also because they reiterated arguments. There was no need to complement the complaint in any way, shape, or form. There's also a violation in connection with the principles of consistency and completeness. These alleged irregularities are not a violation to the principles. The arguments are there to challenge the interpretation of the Federal Administrative Court, and this does not lead to a violation of the rights of the contractors. In connection with the alleged omission by the Federal Administrative Court to analyze the grounds for the rescission in 15R of the contract, I don't think that omission exists because this was not included in the annulment proceeding. Of course, the tribunal should only decide on the basis of the claims put to it. But this was never put by the claimants. By way of conclusion, very quickly, members of the tribunal, the contracts are administrative in nature. None of the contracts is enforced today. The jurisdiction to hear disputes arising from them should always have been an administrative court jurisdiction, at least starting in 2018. There is no illegality or irregularity in the proceedings. I didn't really identify any kind of act or determination that was contrary to the principles or justifications. And I considered that the term of the proceedings was in accordance with the remedies that were available to the parties and to the acts challenged. Thank you very much. Thank you very much, Mr. Asali.
Claimants for cross-examination.
Hey, Mr. Asali, I'm Andrew Melsheimer. I just want to understand, you are presented as an expert in what exactly?
I am a procedural law expert. My expertise has to do with that. My law firm deals with matters that are civil matters, administrative matters, and commercial matters, and also arbitration matters.
Just so I understand correctly, in essence, you're a litigator.
That's right.
Are you presenting yourself as an expert in contracts?
In all litigations, if the subject matter to be studied entails a contract, one has to know the subject matter that you're going to be presenting on. I think that in this case, I have studied the contracts in dispute in this arbitration, and I do know those contracts.
Have you ever drafted a contract like the 821 contract?
I have not.
Have you ever drafted a contract like the 804 contract?
No, sir.
When was the last time you drafted a contract?
Last week.
Usted me preguntó.
You asked whether I drafted contracts such as the ones that are now in dispute, but the answer to that question is no.
When was the last time someone hired you to draft a contract for them?
Not long ago, sir. Last week, I was drafting a contract. It wasn't an oil contract, but of course, depending on the subject matter, that's something that we could do.
Contrato de suministro.
It was a contract. It was a supply agreement, a supply contract.
And the contract before that you drafted, when was that?
Well, I'm going to have to jog my memory, but it is true that my expertise in the drafting of contract is not as great as the one that I have in litigations. But you asked me whether I have drafted contracts, and the answer is yes.
Different question. In the past year, how many contracts have you drafted for clients?
I do not recall. Suddenly, at the top of my head, like you would say, I cannot recall, but 3 or 4.
Do any of those contracts have a clause about administrative rescission?
No, sir. No, sir.
Do you have a copy of your resume in front of you?
No.
I do not.
Mi currículum.
My CV, you said. My resume. Oh, okay. It's on the screen. Well, it was on the screen. Can you please show it again, or if it can be shown on the screen?
Certain disputes. The first one being an LCI arbitration. That was not an administrative matter, was it?
Sí lo fue. Fue un.
Yes, it was administrative in nature.
It was an administrative contract?
Sí, señor.
Yes, sir.
And what was the contract about?
The construction of a dam. This was a contract made by the Mexican government.
Defendimos al.
We defended the contractor.
Did it have an administrative rescission clause in it?
Sí, señor.
Yes, sir.
What's that clause?
Yes, sir.
I see the next one is an arbitration, Alicia Grace. What was that arbitration about?
This was an investment arbitration. I was there as an expert witness for Mexico for purposes of the disputes in that arbitration.
And what was your expert testimony about?
It was very similar to this arbitration. It had to do with the validity of administrative contracts. the termination of the administrative contracts and the bankruptcy implication of those contracts.
When was the last time you personally were before an administrative court in Mexico?
Let me explain. My law firm, well, if you're asking about me personally to appear before an administrative court, the answer is last year. Now, if your question is, has my law firm been involved in administrative matters, the answer is every day.
I want to focus only on you. How many times have you been before an administrative court this year?
No, no funciona.
That's not how that works, sir. In the case of Mexico, I do not appear before a tribunal to litigate in front of a judge. Things are done in writing, and these are submitted to the judges. Have I participated in the drafting of those briefs? Yes. I have done it throughout the past year.
How many times throughout this past year have you presented papers, you and you alone, to an administrative court?
Yo solo en ningún caso.
I myself, never. I was always a representative of my law firm.
Firm presents papers to an administrative court, but you do not, correct?
I am involved in the drafting. This tribunal, I'm sure, has seen that there were complaints that were filed, and you see there that the signature of the client appears, and those that participate in the proceeding, in the case of the matters put to our law firm, where you're going to find my name there.
Have you personally represented a client with respect to an administrative rescission?
Yes. In the LCIA case in my CV.
I'm not asking about a commercial arbitration. I am asking about you representing a client in an administrative rescission in Mexico.
Yes.
When was the last time you did that?
I do not recall off the top of my head, but 1 or 2 years ago.
So in the past 2 years, how many times have you represented a client in an administrative rescission proceeding in Mexico?
Once or twice, maybe.
How about the last 5 years?
No sabría decir.
I wouldn't be able to answer that question. I do not recall.
Explain to me a little bit about the preparation of your expert reports. For your first expert report, did you draft it by yourself?
Together with a lawyer from my office.
And what is that lawyer's name?
Alina Aguilar.
She here?
Sí.
She is.
What did she write?
Sería imposible.
It would be impossible for me to say. It would be impossible to say who prepared what section. It was prepared jointly. And at the end of the day, everything is reviewed and authorized by myself.
In drafting your first report, how did the drafting process go? Did you exchange drafts with your colleague back and forth?
No.
I did not. Generally, you have a table of contents and you start developing the items in the table of contents. You do research, you share ideas, and that takes shape. Very similarly, I think, to the way in which you submitted your complaint to this arbitral tribunal. I do not know of any other way to do it.
Did you share copies of drafts with Mexico? before finalizing it?
No.
I did not.
What about the law firm of Pillsbury?
Tampoco.
No, they didn't either.
So in your first report, you mentioned that you reviewed the contracts, the files, and records of the civil and administrative trials initiated by the claimants. Given a binder of documents?
Es correcto.
That's correct.
Se nos facilita.
We were provided an internet drive and also a binder of documents for our analysis.
And who gave you those documents?
The Minister of the Economy.
So is it fair to say that you had the record of the administrative rescission proceedings for the 821 contract?
Se nos
We were provided some portions of that proceeding. That's correct.
Do you recall what documents you saw?
No, not every single one of them. I saw the complaint, I saw the finiquito, I saw the contract, I reviewed some of the rulings, judgments.
For your second report, how many times did you review it before it was issued in this arbitration?
debo haberlo.
When we started drafting it, and then we reviewed it, and then we finalized it perhaps 4 or 5 times.
And you say we, who are you referring to?
Hablo en plural.
I speak in the plural. You talked about my involvement, and I talked about my involvement myself.
So only you wrote your second report?
Nuevamente.
Again, the drafting process was very similar to the one that we used in the first report. In this case, Ms. Aguilar provided her help, and we examined the answer by Galicia, and we prepared a table of contents. We drafted the words, and then we reviewed everything, and we sent it to the Ministry of the Economy.
Just so I understand correctly, you and your colleague alone shared drafts of this document before it was sent to the Mexican state, correct?
Could you please repeat the question? I didn't really understand the context of it.
I'm just trying to understand the process of preparing your second report. Someone drafted an initial version, someone reviewed it, there were further edits, and it was just you and your colleague who's here with us today, correct?
Salvo por la parte.
With the exception that you said somebody else drafted it. The drafting was joint. Well, yes, I do resort to others for certain portions and investigations. After a review, we send it to the Minister of the Economy.
Help me out. How many people in total were involved in the preparation of your second report?
I wouldn't be able to tell you. Perhaps a paralegal from the law firm was asked to help with the investigation of one of these unified legal criteria on a point of law. I cannot tell you 3, 4 people that helped us conduct a research of the fact, but at the end of the day, I am the author of the report. I reviewed the report, and I am the one who signed it.
And when you sent it to the department or the Secretary of the Economy, did they send you back comments for further revision?
No, me preguntaron.
No, I was asked about doubts, And I dispelled their doubts in connection with certain assertions that I made or the reasons for the assertions, and that was it.
Did you make any changes as a result of these comments that you received from the Secretary of the Economy?
No que yo.
Not that I can recall.
So you reviewed it carefully before it was sent, the final version was sent to the Secretary of the Economy, correct?
Generally, okay, there may be a typo or an error. In this case, we said that there was an amendment of the complaint, and that did not happen. That had not happened. There are always issues with the drafting of a document. It's something fallible.
Just so I understand correctly, you drafted a report along with your colleague who's here with us today, and perhaps a paralegal, and you cited an exhibit that doesn't exist?
Es correcto.
That's correct.
How did that make you feel?
Well, I was upset. Nobody wants to make mistakes.
Were you not looking at documents when you drafted this report?
I was.
What document were you looking at when you drafted footnote 110 of your second report?
Evidently, if we are making reference to the amendment of the complaint, well, this was an error. Perhaps it came from a prior footnote. I don't know if I relied on a line that should have been deleted. I don't know. That's the answer. I don't know. Evidently, this was a mistake, and that is why it was left there.
So your testimony is that the citation to an exhibit that doesn't exist is the error, correct?
Sí, señor.
That's right.
Sí.
Let's look at paragraph 87, please. Let's look at the second sentence. It says, neither the demand nor the extension shows that. What extension were you referring to when you drafted paragraph 87?
Perhaps I wasn't clear when I said that this was a mistake. There was no amendment or expansion of the complaint. At that time, perhaps I was confused. There are other proceedings that include an amendment of the complaint, an extension of the complaint.
I'd like to look at the 821 contract. In your first report, you gave us an analysis of certain provisions of the 821 contract, correct?
Sí.
Yes.
You did not analyze clause 15.1R of the 821 contract, correct?
I think that mention is made of that at the end, but there is no deep analysis of that. No, that's my answer.
Did you not think clause 15.1R of the 821 contract is important?
To be honest, I did not. My answer has to do with the fact that when I reviewed the court documents, I didn't see in any of the documents that were submitted by you any mention to that clause. So, at the time, I didn't think that that clause was as relevant because I was analyzing all the matters that were put to the court.
I'm referring to your testimony about being a contract expert. Do you not think Clause 15.1R of Contract 821 is important to this dispute?
I think that all the clauses of every contract are important for this controversy. In my initial analysis, this clause was not examined by me because it wasn't included in the court documents that I examined. What's more, in the amparo that I examined and that arose from the administrative proceedings of 821, there it specifically says that this was a novel argument that could not be examined by the tribunal because this had not been the subject matter of the administrative proceeding. That is why I didn't think that this was critical at the time.
Well, my question is, when you were drafting your first expert report and you were reviewing all the clauses of the contract and providing summaries, why did you not include Clause 15.1R?
The answer is that in the documents, in the court documents that I had examined in connection with the contract, that was not included, and I didn't think it was critical. I still think it is not critical for purposes of the decisions made in Mexico.
You do understand that an issue in this arbitration is Pemex's administrative rescission of the 821 contract because of one unfulfilled work order, correct?
That is incorrect. That is incorrect in light of the analysis I conducted. It wasn't just a single work order. There were breaches that were environmental in nature. There were changes in domicile, and the judge's rulings considered that this was the case. I'm not going to put myself in the judge's position or in the judge's shoes, but I don't think that this had to do with a single work order.
So it is your expert opinion, reading in contract law, reading the 821 contract, that Pemex was able to administratively rescind the 821 contract because of one unfulfilled work order?
I think that the answer can be found in Clause 15 itself. It said that any of the assumptions for administrative rescission, if any of those came up, if the adjudicator considered that that work order that went unfulfilled, if the adjudicator thought that that was sufficient, and that was his opinion, that was a decision made in accordance with Mexican law. Now, you're asking if any of these assumptions came up, that was enough for administrative rescission to take place.
So is your answer yes?
Sí.
Yes.
I'd like to show you Clause 3 of the 821 contract. But before we do, you do agree with me the plain words of Clause 15.1 says that Pemex cannot administratively rescind the 821 contract unless there are 15 unfulfilled work orders, correct?
No coincido.
I do not agree. Subparagraph R does provide for that, but there are several assumptions, several presumptions under the possibilities or the options of the fifth clause that gave Pemex the possibility to rescind such a contract.
Principle of law that a specific contract provision prevails over a general contract provision?
Sí.
Yes.
Agree with me that clause 15.1R is a specific contract provision?
All of the assumptions under 15 are specific. This is another one from the list of such a clause.
3 of the 821 contract. And let's look at the next page for clause 3. You've read the good faith clause, I believe, correct?
Sí, señor.
Yes.
I like to focus on B. As an expert in contracts, what is your understanding of Pemex's obligation under this clause?
Ambas partes debían
Both parties needed to cooperate and consult with each other as necessary to attain the total completion of the works. Clearly, the idea with the signing of the contract was to perform the works contracted within the terms expected and also based on the monies that were to be paid to the contractor.
Portion of this clause. It says the totality of the works. What does that mean to you?
que las partes
That the parties had to see that the totality of the works were completed. I think that it is a natural clause and a regular clause whenever one initiates a contract relationship that is intended to perform or to comply with the object of the contract.
Okay, can you put a number on what totality of the works means?
100%.
100% of what?
Los trabajos que pretendían realizar.
Of the work that had to be carried out.
And what are those?
Las obras contratadas.
The works contracted, the wells to be carried out, what the parties expected at the time of signing the agreement, the contract.
Is there a monetary amount for this, or a number of well amount, or what?
Ahí lo
I said it in my presentation, there was an amount. I think that the minimum work had to do with $168 million up to $441 million.
So you agree with me? Well, let me ask you a different question. In your expert opinion, what was Pemex's obligation to the contractor under this contract?
contratar por
To contract at the very least the minimum amount of work agreed.
The obligation was to request work from the contractor, correct?
efectivo.
Indeed, that is true within the term agreed. And if I recall correctly, it was from 2014 to December 2017.
And would you agree with me that Pemex had the same obligation under the 803 contract and the 804 contract?
No en cuanto al 8.
Not in connection with 803, but they did in connection with 804. 803 did not have a minima and a maximum, but 804 did have a minima and a maximum.
Just so we're clear. So the 803 contract does have one number, and so under that contract, Pemex agreed to request work for that amount of money, correct?
Sí, pero hay un
Yes, but there is a very important exception. The parties agreed to sign a finiquito. that finiquito established the numbers that had been worked and the ones that would not be worked on and the ones that would not continue. And as part of that finiquito, I do not want to make a mistake, but I think $403,000 as a balance that was outstanding to be paid. The parties, by signing the finiquito, terminated the contract, and the only portion that was still in force as of that date was agreed specifically in the finiquito. What am I trying to say? That regardless of what it's stated in 803, as of the signature of the finiquito, only what is stated there is whatever was in force. And this is identical to what happened with 804.
So are you referring to Clause 2 of the 803 contract?
No sabría de memoria si me la enseña con...
Yes, I don't know it off the top of my head, but if you show me, I can confirm.
Are you saying that there is a juridical act that has extinguished all of the rights and obligations of the parties?
Sí.
Yes.
What act is that?
Finiquito.
The finiquito.
The finiquito for the 803 contract has a reservation of rights, correct?
Sí, señor.
Yes, sir.
So as an expert in contract law, you're saying that a document that reserves rights also extinguishes rights?
As you put it, it's not correct. Starting with the finiquito, the obligations that existed under that contract will be exclusively the ones agreed within the finiquito. Everything that was not included in the finiquito was completely terminated. In the case of 803, there was the contractor was not reserved except for the payment of a specific amount, $403,000, as well as the right to claim in case there were sunken costs, and I think that some indirect costs due to financing. Those issues were still alive based on the finiquito, not the contract.
For the 803 contract became a part of the 803 contract, correct?
No, señor.
No, sir.
Testificó.
Even the expert declared that the finiquito is independent, and that puts an end to the contract in this case, except for some specific situation that in that case did not apply.
I believe it's 17.
Sí.
And if we look three paragraphs into clause 17, it says the document that consists of the finiquito of the works will form a part of this contract, correct?
Sí.
Yes.
To avoid having to go through each one of the contracts, would you agree with me that each of them contains a similar provision?
Sí.
Yes. All of the contracts have a clause related to its finiquito.
Argument that a finiquito terminates a contract, but also becomes part of the contract.
Termine el contrato.
It terminates the contract, but it is not part of the contract as of the date of the signature of the finiquito. The rights and obligations survive, mutate, or modify only what the parties thereby agree. It might not be the best draft where it says that it will be part of this contract. If you read the paragraph, the next paragraph, it says, if necessary, PEP shall request the contractor in the finiquito the presentation, extension, reduction, to comply with, to endorse the obligation that should be complied with after termination of the contract. The contract is concluded after the finiquito, and only the rights and obligations agreed in the finiquito shall continue.
The 821 contract?
Le voy a ser sincero, es un documento de 30.
To be honest, there are 35 pages. I didn't read it completely. I reviewed it.
And I'd like to look at clause 12. Do you agree with me? And this is for clarification, this is a document that Pemex itself drafted, correct?
Sí.
Yes.
Unilaterally, if I remember, correct?
Correcto.
Correct.
Do you agree with me that in writing this language, Pemex believes that the 821 contract is still valid?
Comparezco aquí en mi calidad de experto.
I am here as an expert. Clearly, this is a terrible mistake in a finiquito document because of two reasons. First, this contract had already been rescinded administratively before. Clearly, when PEP drafted this, they took a format and they did not realize of what it said. And by attempting to reserve rights to probably, and here I may be speculating, to demand the payment of the Dorama bond, they left this clause. But this is incorrect. As of the rescission of the contract, it was no longer in force.
30 seconds. Perdón. Sobre el lenguaje.
In connection with the language, the first phase says the closing of this contract shall take place. What I understand is that this contract will not be closed until. Is it the same way it is said in Mexico, or is it normal to remove that negation? Is it a typo, or there is a use in Mexico that is different from what we have in other Spanish-speaking countries? This is just from the linguistic point of view. I think that here we have another interpretation. It is perfectly read in Mexico the way it is. I think that this is not a reading problem.
It's in Spanish.
In English.
No, in Spanish, and then to have the translation into English.
Please, Mr. Sali.
Con gusto.
The closing of this contract 421004821 shall take place until the contractor pays all of the amounts mentioned prior to indicating or after indicating that PEP reserves the right to carry out any judicial, administrative, or jurisdictional action deemed necessary to enforce their rights.
Testimony that this is a mistake, correct?
No lo entendería de alguna otra manera.
I wouldn't understand it otherwise, given the administrative rescission of the contract that had already taken place. And here we should clarify something. If my memory serves me right, the claimant requested some precautionary measures when bringing the claim, I imagine is the administrative claim, whereby it was admitted that PEP could not issue the Finiquito Act and only when the procedure had been completed. That's why PEP took so long in drafting this Finiquito Act and document, and this must be a mistake because due to judicial decision, it is inadequate legally.
I'd like to go to page 33 of the unilateral finiquito for the 821 contract. And let's look at the bottom. For the benefit, could you read that for us, please?
Claro, dice, asimismo,
Likewise, and in conformity with the final paragraph of Clause 18 Finiquito of Contract 42100481 that establishes Clause 18 Finiquito.
4.
you want me to read?
Please continue.
The contract will come to an end once the finiquito is signed or whenever there are balances in favor of any of the parties until the date that those amounts are duly paid.
Is it your expert opinion that this was a mistake too?
¿Me puede especificar también?
Would you please be specific? What are you referring to?
Why do you believe Pemex included reference to this provision in its unilateral finiquito?
Partiendo de la base que yo
Starting from the basis that I did not draft it, I imagine that it must be that the Finiquito Act was being drafted and they wanted to include the legal source for it.
This unilateral finiquito, Pemex has reserved rights against the contractor and is also making claims for monetary damages against the contractor. Do you agree with me?
sí.
Yes.
So reading the clause that we just read, would you agree with me that the 821 contract remains in effect?
No, señor.
No, sir, I do not agree. It started with the administrative rescission, the contract came to an end, was terminated.
In your first expert report, you did an analysis of the 809 contract. Do you remember that?
Sí, señor.
Yes, sir.
I'd like to look at a document called an Acta de Extinción. Specifically, and let me just preface, this is a document on Pemex letterhead, correct?
Sí.
Yes.
Is this an official, maybe an administrative document? Would you agree with me?
Así parece.
It looks that way.
Let's look at the paragraph that starts with de conformidad.
In accordance, de conformidad in Spanish.
¿Gusta que lo lea?
Please.
Do you want me to read it?
De conformidad con
In accordance with clause 18th of the contract, 6th paragraph of contract 3809, the following act is taking place to terminate all of the rights and obligations of the parties derived from the conclusion of the validity of the contract mentioned.
Pemex and the contractors for the 809 contract had signed a finiquito, correct?
No recuerdo.
I do not recall.
Perdón, no lo recuerdo.
I'm sorry, I do not recall.
Yes, if you could just state for the record the previous exhibit.
The last exhibit was JAH 66. And we're going to JAH 63. This was attached to your expert report. Does this help? Why did the contractor for the 809 contract and Pemex need an acta de extinción if the contract ended with the finiquito?
Porque derivado del...
Because from the Finiquito Act, the parties reserved right to determine later on the non-recoverable, the sunken expenses from the contract, and there was a decision was made to sign this act to terminate the rights as part of what the provisions of the finiquito. It doesn't mean that the contract continued to be in force, but given the agreement under the finiquito, the act, the next document was issued and the documents were reserved.
And I apologize that the hour, maybe I'm confused. Only certain reservations of rights are preserved, or all reservations of rights are preserved?
It depends on the finiquito. It depends on what is established in the finiquito.
Agree with me, if a contractor reserves rights under a finiquito, those rights are preserved.
Claro que sí.
Of course.
Let's look at the 809 contract, the finiquito clause that we just cited in the acta de extinción. Could you read the last paragraph that's been expanded upon?
La vigencia del contrato concluirá hasta que se forme.
The validity of the contract will come to an end until the signing of the finiquito or unless there are balances in favor of either party until those balances are completely paid off. And this agrees with 804 and I think 821.
And this is Exhibit R98. Do you agree with me that this is the paragraph that was referenced in the acta de extinción for the 809 contract?
Sí.
Yes.
I had a question about two paragraphs in your first report. It's going to take a minute, but if you want to look at paragraph 49 and paragraph 56.
49 and?
56. I just want to reconcile. Here you're talking about the minimum budget. First in paragraph 49 about the 804 contract.
Mm-hmm.
And you say, in any case, MWS and Basel could have claimed the issuance of additional work orders by PEP to reach the minimum budget, so that PEP would be bound to pay for work actually performed. You see that? What's the mechanism under the 804 contract for that?
I was referring to the right to claim payment judicially. The question was whether it was possible or where it should reach the minimum amount, pay or claim the minimum amount under the contract. In my opinion, it is difficult for a judge to reach a judgment without a specific amount, and that's why I imagine that one of the possibilities was to claim, as we saw in contract 821, so that the contract continued to produce work orders. The minimum budget refers to the $22 million that had been reserved by claimants when signing the finiquito.
Totality of the works that we were talking about earlier?
Probablemente.
Probably.
So in paragraph 56, you say, PEP could validly use the entire execution period to issue the work orders it required, without the contractors being able to require PEP to issue work orders before the end of the execution period. What do you mean there?
The civil claim for 821 was brought before the work performance period agreed under the contract came to an end. I attempted to introduce a pause in my presentation and refer to that. The performance period under the contract had not concluded, but forced compliance had already been demanded, and under Mexican law, I think it is Article 1958 of the Federal Code of Mexico, the Mexico City, that term is always considered in favor of the debtor. So, in my opinion, the whole period agreed by the parties had to run to be able to ask PEP or be able to claim before PEP or ask PEP why they had not issued work orders that completed the minimum budget under contract 821.
With what you told us earlier about Pemex's obligation to issue work orders under the contract. Pemex had an obligation to issue orders under the contract, but in paragraph 49, you say, as I read it, it did not have an obligation to issue work orders.
El párrafo 40.
Paragraph 49 refers to contract 804. And paragraph 56 refers to contract 821. They're different situations. In Contract 804, a finiquito was signed. In Contract 821, there was none. In Contract 821, its perforce implementation was claimed, even though the work orders had not been issued. So the situations in 49 and 56 are different. Each one answers to the particular contract.
So that's a no? Pemex did not have to issue work orders?
No.
No, that is the cause why, that explains why paragraphs 49 and 56 of my opinion answer to different contracts. Pemex, as per agreed in the contracts, was under an obligation to issue work orders. In my opinion, at least for the minimum amount agreed upon, a situation which in 804 was modified by the signing of a finiquito, and in 821 by the administrative rescission that affected that document.
Is that the 804 contract is different than the 821 contract?
No.
No, that's not what I said. I said that the situations after the contracts, in one case finiquito, and in the other the administrative rescission, led to different situations.
Yeah, I'm talking about before the finiquito and before the administrative rescission. So let's...
Es correcto, son lo mismo.
They are the same.
Answer taking those issues off the table.
They are the same then. Contracts 804 and 821, prior to the finiquito and prior to the rescission, contain similar clauses.
You were here when I cross-examined Mr. Lustenau, right?
Sí, señor.
Yes, sir.
I'd like to get your opinion for the 821 contract with respect to the good faith obligation that Pemex had under the 821 contract. Keeping in mind clause 15.1R. Was it good faith for Pemex to initiate an administrative rescission based on one unfulfilled work order? And let's take out the PACMA and let's just focus solely on the work order. Was it good faith for Pemex to initiate an administrative rescission based on one unfulfilled work order in light of clause 15.1R?
You're asking me two different things, because mindful of what Mr. Lustenau stated in his testimony, he said, if I remember well, that he did not find anyone at the company, that the company had apparently abandoned the work. Now, I'm not a witness to, nor did I participate in, what actually happened. All I can do is give testimony with respect to the legal issues that I analyzed. Now, under that analysis, and mindful of clause 15.1, which states that any of the grounds, including letter R that you have mentioned, may or may give rise to administrative rescission, the answer is it wasn't necessary for them to have 15 work orders unfulfilled in order to bring a claim for its administrative rescission.
So your testimony is that clause 15.1R of the 821 contract is pointless?
No.
No, it was one more situation that Pemex could draw on to uphold the administrative rescission, which, well, I'll leave it at that. Sorry.
Why do you believe, as an expert in contracts, that the 821 contract has a clause like 15.1R?
I have asked myself the same question throughout the hearing. I have no idea to whom it occurred to include such a clause or why 15. I don't understand the logic or of the clause or where it comes from. I don't know.
In your expert review of the 821 contract, did you look at clause 6?
Contractual penalties, yes, I did.
Did you see clause 6.6.1?
Sí.
Yes, and I don't remember exactly what it says off the top of my head.
And if we could look at 6.6.1 A.2. We're working on the technology.
Don't worry.
1 minute. It never works when you want it to, does it?
Así pasa.
For the benefit of
That happens.
tribunal, if you could read in Spanish whatever you are going to ask for everybody to understand the
And this is Exhibit R3 for the benefit of those keeping exhibit numbers. If we could expand 8.2, please. Could you read that clause, Mr. Asali?
Con gusto.
Yes, I'd be pleased to do so. Contractual penalty for delay in initiating drilling work orders or work orders for drilling in the event that the contractor, for causes attributable to it, does not start the operations in the proper time and form at the start date established in each work order issued for the drilling of wells. PEP will apply a contractual penalty for the sum of $17,500 for each day of delay counted from the start date established in the work order in question and up to the date when the contractor actually begins operations, inclusive. This penalty shall be applied for up to 15 days maximum, after which, if the contractor has not begun the corresponding work, the work order shall be considered unfulfilled, and then PEP will be able to issue a new work order. The penalties indicated herein shall not be applied if the contractor complies with the time period established in the work order.
Where else in the 821 contract it refers to a work order being, in Spanish, incumplida?
No lo recuerdo. Recuerdo.
I don't recall. I remember compliance. I think it's clause 4, but non-compliance, I'm not sure. I think that might be in another part of the contract.
Can we look at clause 15.1R again, please? Do you now have a better understanding of why Clause 15.1R exists in the 821 contract?
Once again, this clause is one more of a list of situations that Pemex could draw on in the event that it were to decide to rescind the contract. It's clear to me. It says that for this provision, the contractor should accumulate 15 unfulfilled work orders.
6.1. With respect to work order 28-2016, Pemex had the ability to charge the contractor $17,500 a day up to 15 days, correct?
Sí, señor.
Yes, sir.
But it chose not to, correct?
Yes.
Instead, it waited until the finiquito in November 2021 to make this claim, correct?
No es incorrecto.
No, that is incorrect. It sought first, no, it administratively rescinded the contract. The moving party or the contractor brought a legal action. It was there, the contractual rescission was affirmed both by the administrative court and by the Amparo court. And then, after the contract was rescinded, the finiquito was signed. Why? Because there was a precautionary measure sought by the moving party that impeded it.
As an expert in contracts, what's the purpose of Clause 6.6.1A2 if Pemex can just administratively rescind the contract for one unfulfilled work order?
Lo que yo he visto en este tipo de...
What I've seen in contracts like this with public enterprises is that they're contracts that have a multiplicity of options for performing on the contract or acting as they wish. It has contractual penalties, powers of rescission, powers of termination, powers of suspension. As it is public resources that are subject matter of these contracts, the public administration reserves all types of powers as part of caring for public resources. Now, in this case, what you say, I understand. Why did they have rescission, termination, suspension, and contractual penalty? Well, that's how these contracts are written. So I understand that the contractor received advice when signing it, knew what it was signing, it signed it freely, and therefore was aware of the risks of a contract for works of this sort.
You do agree with me that a contract must be read in its entirety, correct?
Yes, sir.
There was a question posed earlier, and I believe you were here for it. There's a special protocol when it comes to communications that I've found in Latin America that people stamp or sign letters when they receive them. Are you familiar with that practice?
When
one who receives a communication receives it, they sign it?
No.
No, I was not familiar with that.
Not with a government entity?
No, me parece.
No. What I know is that they sign all the sheets, as you can see in the document that's up on the screen, to be certain that it is that document and not some other one is what was signed. Not when they receive it, but rather when they enter into any sort of contract, which is absurd if you ask me, but it's the only way to ensure that their signature's there.
Let me ask a different question, and take this off the screen. In general, if I were to write a letter to Pemex, I would deliver the letter. Typically, I'd have someone sign that it was received, maybe stamp the letter. You're familiar with that practice?
Por supuesto.
Okay.
Of course.
Same. Pemex sends me a letter. I receive the letter. I sign it, saying people want proof that it's been received. You're familiar with that practice?
Sí.
Yes.
Por eso,
And that is why, to ensure that a communication has actually been received by the person to whom it's sent, if it's not signed, then one uses a courier or a notary public who can attest to the fact that it was actually sent and received.
Correct. There would be proof of delivery.
sí, señor.
Yes,
Important, right?
Siempre.
always.
If we could show Exhibit R109. Technical difficulties again.
In the meantime, Mr. Mersheimer, just for planning purposes, because we are just 10 or 11 minutes shy of 6:30, how long, could you give me a ballpark for the additional time you will need to finish the cross-examination, just for planning purposes tomorrow?
About an hour.
1 more hour. Okay. So we'll continue until 6:30 if that's okay with you, and tomorrow we'll have slightly less than 1 hour. Then we'll have the redirect and recross and the questions. So probably tomorrow we can start at say 9 a.m. That will be enough, and we will be finished by 10 p.m. There will be breaks, but no lunch break. Okay.
10
So,
p.m.
please.
Sorry. Presidente, te dijo 10 de la noche.
You said 10 p.m.? 10 a.m. for ending the cross. I know that we like to torture the witnesses and experts, but not so much.
Yeah, I'm waiting on the technology.
And then again, here it is.
This was brought up earlier. And if we could look at the top or anywhere on the page for that matter, do you see any, what we're just talking about, received, signatures, stamps?
No hay en este documento
No, this document does, just from glancing at it, there's no additional signature that I can see.
Do you receive a lot of communications from government entities like Pemex?
No.
No.
Agree with me that they'd be very careful to sign things when their names appear.
Coincido en que
I agree that normally one seeks the signature of the person to whom it is sent to ensure that it's been received.
At the bottom. I assume they couldn't find Mr. Perez to sign this letter that was allegedly sent, right?
No lo sé.
That I don't know.
We talked a lot about clause 15.1R. It's an important clause.
Mr. Milsheimer, can you just tell me why Mr. Perez? Where do I find the reference to him, or why do you mention his name?
If we could look at R109. And if we look at the bottom, Mr. Perez apparently prepared this letter that Mr. Gomez signed, and if we recall, Mr. Saleh wouldn't, I don't believe you would know these facts, but for the benefit of the tribunal, Mr. Perez was Mr. Gomez's boss. So going back to clause 15.1R. And I think we talked earlier, your first report did not mention clause 15.1R of the 821 contract.
Lo comentamos.
Yeah.
Yeah, we discussed that.
But your second report does, right?
Correcto.
Correct.
But you don't analyze it in your second report, do you?
Yes, I do analyze it in the second report.
I'd like to find where.
Por ejemplo, párrafo 87.
For example, at paragraph 87, paragraph 83, paragraph 82.
Referenced it. I'm referring to where you analyzed it.
Realmente
Well, there is not really an in-depth analysis of the contractual clauses, but rather as an answer to what was indicated by claimants experts. Now, in the specific case, clause 15.1R is mentioned to emphasize that there was no need for it to be invoked by the administrative court, since emphasis was never placed on this in the complaint. This is a situation that's corroborated by the Amparo Court. For once its existence and the alleged lack of violation thereof was made known to it, keenly, in my view, the judge on Amparo indicated that he could not get into this because it was a novel issue that had not been argued before the underlying court.
I'm sorry, so you didn't analyze it because a court had put it in a judgment?
no era objeto de mi opinión.
It wasn't the subject matter of my opinion, except for jurisdictional purposes.
So I'm just trying to understand as a contract. I write contracts myself. From what I'm understanding from your expert testimony, I have clause 15.1 in the 821 contract for administrative rescissions, which you'd agree with me, an administrative rescission can be a draconian remedy. Correct?
Puedo coincidir.
I can agree with you.
It's a draconian remedy?
En algunos supuestos puede llegar.
In some cases, it might reach that point.
So I'm a contractor, and I'm confronted with one unfulfilled work order. The draconian remedy is to administratively rescind the contract. That's your opinion?
No. Bueno.
No. Well, in the specific case, no. Because I understand, based on what we analyzed, that it wasn't just one work order.
On the work order.
Es muy difícil para.
It's very difficult for me to be able to say that this was a draconian measure, since if I also take into consideration what was noted by Mr. Lostano, who said that apparently it had been abandoned by the contractor. It's not possible for me to put me in the shoes of Pemex. I can't, I shouldn't, because I'm not familiar with all the relevant facts and how that contract was being seen by Pemex. So here, my factual opinion is the same. I can give my legal opinion, and I believe that, mindful of the clause in the contract, one could rescind it administratively. It may be a draconian measure in some cases. I agree. In this case, was it? That I don't know.
So in your expert opinion, it was okay to ignore 15.1R when there was one unfulfilled work order, correct?
That's not my testimony. My testimony is that the judge who took cognizance of this case was not informed. It did not draw on the need to have 15 unfulfilled work orders, and therefore didn't refer to the clause 15 in the contract. Now, whether Pemex did or did not, I can't say. That's not up to me.
So if the judge was made aware of clause 15.1R, would your opinion change?
Tampoco lo sé.
I don't know that either. Only the judge can know. I cannot guess what the adjudicator thought, what he was brought to his attention, that the PACMA was not raised. There are many situations. In light of the documents analyzed to this day, there's no evidence that that clause was raised to the judge, and what I confirm based on what I then cite what the Amparo judge said, which is that it was a novel argument when this was raised.
Asking for your opinion. I'm not asking for what the judge might or might not have done. What would you have done when confronted with one unfulfilled work order for $1 million under a $418 million contract? Do you think it's okay, you, not the judge, you, do you think it's okay to ignore clause 15.1R in that situation?
Es que no se puede emitir en un vacío.
Well, I cannot give an opinion on that in a vacuum. It might sound like a draconian measure individually. It might not be so if one takes into account everything around the contract.
6:30. So with the agreement of the parties, we stop here and we reconvene tomorrow at 9 a.m. sharp. Muchas gracias, señor.
Thank you very much, Mr. Asali. Now you know that you are sequestered. In other words, you cannot speak with the attorneys from either of the parties. You can watch television, read, or entertain yourself in any other way. With which?
And we'll see you tomorrow at 9 a.m.
Gracias, señor presidente.
Thank you, President.